to night 22 of our 24 nights of live streams, breaking down the 2024 legislative package, the Trump-Biden peace plan. And as always, we start these sessions off with the preamble to the Constitution. Invited to join me in reciting it. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America. Tonight we're going to continue looking at Title V, securing the blessings of liberty to ourselves and our posterity. And tonight's focus is on immigration issues. Immigration is a hot button topic this election cycle, and the whole system needs an overhaul, right? The immigration, the asylum system, it very much needs an overhaul. And as I've said time and time again, Congress is dropping the ball. It is Congress's job to set policy, and they're willfully refusing to do so. I remember when President Bush campaigning 20 years ago on reforming the immigration system, but nothing happens. The political incentives are all wrong, and as we saw earlier this year in February, there was a bipartisan group of senators who came together and worked out a deal, and Donald Trump encouraged the Republican senators to kill it so that he could campaign on immigration being a problem. Now, a lot of that language that we're going to be discussing tonight, that from that February immigration deal, has been adopted, is part of the Trump-Biden peace plan. We'll be talking about that here shortly. But Congress is dropping the ball. Sort of. And I say sort of in that, yes, they're very much dropping the ball and not setting national policy. But there's a larger question here. What does the Constitution actually say about immigration? What is Congress's authority? Well, Article 1, Section 8 spells it out. It says, Congress shall have the power to establish a uniform rule of naturalization. That's what the Constitution says about immigration. So, when people, when Republicans say, we support the Constitution and we want to deport people who are here illegally, well, guess what? Congress doesn't have the power to deport people in the Constitution. It's just not there. That being said, securing the blessings of liberty to ourselves and our posterity does cover an awful lot of things. And yeah, so Congress, even if it's just by the fact, the virtue that previous countless generations of congressmen and women have set border policy, the responsibility falls on Congress to maintain that system and not just let it atrophy and fail to function. So I just read what the Constitution actually says about immigration, which is nothing, and how it gives Congress the power to establish a uniform rule of naturalization. And so the very first Congress in 1790 did that. They passed a Naturalization Act. Our three planks, right? End poverty, end mass incarceration, end the endless wars, addressing Dr. King's triple evils of poverty, racism, and militarism. And ending mass incarceration, racism is very much a part of our criminal justice system. So much bias has been baked into it that it's time for a radical revolution in the way that we do criminal justice system. But, spoiler alert, racism is also very much a part of our immigration. You know what that very first Naturalization Act of 1790 said? Remember, what does the Constitution explicitly say Congress is supposed to do? Establish a uniform rule of naturalization. So what did the very first Naturalization Act do? It limited naturalization to free white persons. That's specifically what they did. They made it very much not uniform. They made our immigration policy racist from the very beginning. Just as a quick technical, just a definitional thing, just so we're clear on naturalization is the process of an immigrant becoming a citizen of the United States. And so again, this is what the framers laid out in the Constitution. People could immigrate to this country, but Congress would establish a uniform rule for when they could actually become citizens and get the benefits of citizenship. You know how long under that first Naturalization Act, you know how long a free white person, immigrant, had to be here before they could become a citizen? 2 years. 2 years. That's it. It's also worth pointing out the Homestead Act of 1862. You might know this is something that Abraham Lincoln signed this. This was Republican policy, part of the Republican platform, to open up the middle of the country to people, to encourage people to settle in the middle of the country. And you know who was eligible to get land grants, land very, very cheaply from the federal government? It was limited to citizens and potential citizens. And remember, the Dred Scott decision said blacks were ineligible to become citizens. So they were very explicitly excluded from the Homestead Act. And again, the framers of that act opened it up to potential citizens. So you could be a free white person immigrating to the United States in 1863, and the federal government would immediately subsidize a land purchase for you in the middle of the country. And if you were a black person, you were ineligible. Racism has been a part of our immigration policy, and that is why it very much needs an overhaul. The overhaul is not within the scope of the Trump-Biden peace plan. It needs a lot of work. But what we're going to look at tonight is I forgot to count, five or six, maybe seven different immigration policies where nobody's going to like all of them. Everybody's going to compromise. Everybody's going to have to give something up, but it's a reasonable middle ground. And like the truce on guns and abortion, these are positions that are relatively popular, that have a majority of support because they're common sense. So let us pull up the first section, section 531. This is, sorry, I got to scroll back up to it here. This is essentially DACA, the Deferred Action for Childhood Arrivals. And you've probably heard about this program because it's been talked about for well over a decade. President Obama started this program, the Deferred Action for Childhood Arrivals, in 2012. And he did it by executive action because, say it with me, Congress was failing to act. And so what this did is for children who had been brought to this country illegally, it deferred any deportation and instead gave them a conditional path to citizenship, the ability to, attend college, the ability to get a job, those kind of things. But Obama did this by executive action. So when Donald Trump came into office, he gave notice that he was going to sunset this. He specifically tweeted, Congress, get ready to do your job. He was going to sunset this provision within 6 months. And did Congress step up and do their job like the president reminded them they're supposed to be doing? No. Instead, they sued and said, oh, you can't change this program because Congress was refusing to act. So let us help them. We have tucked this very popular provision, 74% support, tucked this into the Trump-Biden peace plan. And let's go through it. Let's take a look at what exactly what it does. So basically, this is this applies to people who have been here who arrived under the age of 18, who've been here more than 4 years. And as I said previously, this is a conditional basis for status. So temporary status. Here's the requirements. The requirements that they be continuously present in the United States for at least 4 years and that they were younger than 18. Make sure that they are not inadmissible under other sections of the immigration law, right? There's certain things that you can do that acts, things in your background that can make you ineligible to immigrate here. Has not ordered, incited persecution of anyone, has not been convicted of any felony, something punishable by a maximum term of imprisonment over 1 year, or 3 or more offenses for which they were imprisoned for 90 days or more. So if you have multiple misdemeanors or 1 felony, that would be grounds for revoking this conditional status. And they have to be admitted to they have to be going to college, haven't earned a high school diploma or GED, or just be enrolled in school. So basically, got to keep a clean record, and relatively clean record, and get an education. These, think about it. These are the kind of people that we should want to be citizens of the United States. Right? People who grew up here, people who kept their noses clean, people who graduated high school. There is one other, I don't know if I scrolled past it, but they also have to register with Selective Service for men. Yeah. So, and then to get permanent status, you have to work in this country for 3 years. There is hardship. There's hardship. Yeah, I got to go through a background check with biometric data, medical exam, and if you leave the country temporarily for under 3 months, you can still be counted as being physically present. Where are we at? Yeah, so it's conditional on a rolling basis. And where's the part you got to work for 3 years? Oh yeah, so to get permanent status, you got to meet all of those previous requirements and be employed for periods totaling at least 3 years and at least 75% of the time that they've had a valid employment authorization, unless there are hardships, and so we spell out hardships in there, and that's basically basically it. There's details here about the background checks, the documentation requirements. It's kind of a long list of documents could be used for identification. In my opinion, it's a little unnecessarily complex, but this is the congressional proposal, and so we'll have a compromise, right? Yeah, so, and then I think we finish up here. Documents, other documents, and rulemaking. So, given the Secretary rulemaking authority as well. Oh, and keeping this information, any information collected confidential, for purposes of immigration reform. So once again, these are the qualities you should want in every citizen, whether they were born in this country or not, right? Went to school, didn't commit any felonies, serious crimes, works, all these things. These are good qualities that we want to encourage. And again, this has 74% support. However, I've heard that one reason that this hasn't passed, is because it's too popular. And so members of Congress are trying to save this as a bargaining chip that they can tuck into a larger package of legislation. Well, we can play that game too by lumping together dozens and dozens of popular policies into one legislative package. We can play that game, and we, the people, can come out ahead instead of the entrenched interests in Congress. We can change the way government works and make it work for us, for the marginalized million. All right, so that's DACA, again, popular program. This next section, 532, this is restoring the state option to determine residency for higher education benefits. Back in the 90s, when it was get tough on everything, there was an illegal immigration reform, and one of the policies within it said states were prohibited from offering in-state tuition to non-citizens. So 532, just simple as one sentence, and just repeals that. 533. This would update the access to the registry program for immigrants here more than 10 years. Again, Congress needs to overhaul the immigration and asylum system, and they have for decades. But for now, here's what we're going to do. In 1929, Congress passed a path to citizenship for people who had continuously resided in the country since 1921, that had demonstrated good moral character, were not subject to deportation under U.S. immigration laws, and for whom a record of lawful admission was not available. So essentially, they established an 8-year statute of limitations. I said, look, if you came into the country and there's no record of it, nudge, nudge, wink, wink, and there's no record of it, but it was more than 8 years ago, then okay, it's been 8 years, we're willing to stop worry about that as long as you meet some other conditions. And that date of 1921, it has been updated. It was updated multiple times through the decades. Congress continued to update it until the 1980s, and surprise, Congress hasn't updated it since. So the law is still on the books. The program is still on the books. The whole system, the structure is all in place, except to be eligible now, you have to have entered the U.S. before 1972. So, Section 533 of the Trump-Biden Peace Plan updates that to a rolling 10-year timetable. Essentially a 10-year statute of limitations. Remember, the framers, their first Naturalization Act was 2 years. When Congress put this provision in place, established this program in the 1920s, it was 8 years. We're going to make it 10. And I was kind of surprised to find out how many undocumented immigrants this could apply to. According to an April 2024 Department of Homeland Security report, an estimated 9.5 million unauthorized immigrants in the U.S. arrived before 2010. That is more than 80%. These are long-term residents. And again, they've still got to meet the other basic conditions we're going to look at here in just a second. But people who have been living here a long time, who are members of our communities, we're going to give them a path to citizenship. After 10 years, to say, all right, we're not going to worry about what you did 10 years ago. Again, one of the fundamental concepts of building a new political structure on the principles of nonviolence is the belief, is the recognition in the ability of self-improvement for each and every one of us. To recognize that we are not the same people that we were 10 years ago. That we're all growing and expanding, or we all have those capabilities. You don't have to use them, but we all have that capability. And so to judge someone by something that they did more than a decade ago is not a sound basis for immigration policy, absent other compelling factors. Okay, let me pull up the text of the legislation again, and we will take a look at what exactly the existing law says and what we're going to change. Oops, that's the wrong one. All right, here's 532. It's just that one sentence repealing that old provision. Okay, so striking from the header. All right. So what Congress wrote back in the 1920s to establish this was, you can essentially giving the Attorney General the authority to create a record of lawful admission for an alien. It's a non-citizen of the United States. If the entry occurred prior to July 1, 1924, as the date of such entry, if no such record is otherwise available, and such alien shall satisfy that he, you notice we're making all these references gender neutral, that they are not admissible under updated reference to inadmissibility statutes of this title insofar as it relates to criminals, procurers, and other immoral persons, subversives, violators of the narcotics laws, or smugglers of aliens. And they established that they, enter the United States. And you can see we're crossing off prior to January 1, 1972, the date that Congress has not updated in decades and decades and decades, and creating two different options. One, at least 10 years before the application date, or at least 4 years before the application date, and or younger than 16 years of age on date of entry, and has earned a high school diploma or a commensurate alternative, or is enrolled in secondary school. So this is sort of a DACA-like provision. Again, if you were brought here illegally as a child, then you're not a co-conspirator. You're a child under the authority of your parents. And so minimizing the, again, if you're brought here as a child, not penalizing you for the decisions that your parents made. And has had residence in the United States continually since entry. So there you go. Not super complicated, a 10-year. Now, I understand, here's the rest of the conditions. Is a person of good moral character, not ineligible to citizenship, not deportable under existing law, and effective January 1, 2025. So the Attorney General could reopen that program, make it functional again. There are proposals in Congress where this language came from to make it 7 years. 7 also doesn't seem like an unreasonable amount of time. I've talked with a number of people about this, trying to get people's thoughts, and man on the street, as I canvass for the American Union, trying to get people's thoughts on what they think is a fair. And 10 years is on the very high end of the answers. Again, this is not intended, these sections are not intended to fix our immigration system, but to address a number of band-aids. So if we can offer a path to citizenship to the 80% of people who got here before 2010, the 80% of undocumented who got here before 2010, then that will allow us to, like so many of these other issues, allow us to focus our resources on whoever's left. But let's take the low-hanging fruit, the people who have established stable lives here in the United States, and let's stop worrying about that. Instead, focus on what exactly do we want better policy to be. So I'm not saying 10 years is the perfect answer. Maybe it's 7, maybe it's 5, maybe it's 2. I don't know. But as a place to start, 10 years is a very, very reasonable number. Do I have the polling numbers here? There was a poll in 2021. How do I not have it in front of my notes? There's a poll in 2021, and it only covered 6 or 7 battleground states. It wasn't all of them. It wasn't a nationwide poll, and I think we talked about this. But 79% in that 2021 poll, 79% supported a path to citizenship for the undocumented who'd been living in the U.S. For more than 10 years. Now, I've seen something else recently suggesting that number, a similar poll in those battleground states, that number had fallen, but it was still a very strong majority of support for, again, once somebody's been here for 10 years, to stop, as Brian Stevenson, founder of the Equal Justice Initiative, is fond of saying, we're more than, a person is more than the worst thing they've ever done. And so prejudging someone by something that happened more than 10 years in the past is not good policy, period. It doesn't matter whether it's immigration or criminal justice reform or anything. Statements people have made a decade or so in the past, right? That is not embarrassing photos, or in the case of the governor here in lieutenant governor here in North Carolina, extreme statements made on various websites, things like that. What happened 10 years ago does not automatically represent who we are today. All right, moving on. Okay, these next couple sections are pretty much from the February bipartisan Senate bill that was worked out. Many people are concerned about border security because it's getting talked about an awful lot, and and the news media is good at ginning up fear of things. So what this does is this appropriates $19.2 billion for border security and immigration courts. We have a huge backlog in our immigration system, so we'll look at this here in a second. But it's about $5 billion for Border Patrol. That includes autonomous surveillance tower systems, mobile video surveillance systems, and subterranean detection systems. $5 billion for Border Patrol. About $11 billion for immigrations and customs enforcement. That includes hiring, improving detention facilities, and increasing deportation flights, and for an asylum appeals board. There's about $1.5 billion for FEMA, the Federal Emergency Management Agency, and then about $5 billion for immigration courts. How popular are these? Well, 58% support more money for immigration courts, 74% support more funding for border security. That immigration courts, that includes judges, other support staff, and it also funds legal representation. So we're going to get into, after that, legal representation for 2 classes of defendants in deportation hearings. There is some overlap in these categories I just rattled off. They don't add, that's why the numbers I listed don't add to exactly 19.2 billion. There's some overlap. But again, the Senate already worked this out. It was a reasonable middle ground, and so we took that compromise and plunked it into the Trump-Biden peace plan. Let's go ahead and take a look at this, and then we'll talk about Section 536 in a second. All right, and, additional funding. Again, more money for immigration judge teams. You can see here money for representation for certain incompetent adults. We're going to talk about in section 536. And all of these have all these provisions have qualifiers that they are designated as being an emergency pursuant to the Balanced Budget and Emergency Deficit Control Act of 1985. More money for the U.S. Marshal Service, operations and management, custom border protection, procurement, constructions. This is where we talked about the mobile video systems, unmanned aerial systems, all of those things. FEMA. So some of this is conditional. 100 million is for Operation Stone Garden, which I'm spacing out at the moment here on Operation Stone Garden. And it is broken up so that not less than 20, so at least a quarter of it shall be for states not on the southern border. This is a program of grants to the states, then make sub-grants to local law enforcement agencies, and this is it's providing funding to enhance the capabilities to, quote, support joint efforts to secure the United States borders. So border enforcement, and at least 25 million goes to states not located on the southern border. The other 1.4 million is for shelter and other related activities, except 400 million of that is conditional on ICE improving their, increasing their number of officers and things like that. So, all right, another 7.6 billion for ICE, divided for detention capabilities. 150 million for an asylums appeals board, 112 million for operations, 500 million for facilities, and then 350 million for refugee and entrant assistance. And then those are the kind of the appropriations, and then there's also has to be an authority to hire the additional personnel, and so that's what this next section 535 does. So section 535 gives the authority to hire for all those positions. All right, section 536. This is appointing authority to appoint counsel to certain individuals. All right. What's our first duty under the Constitution? In the preamble of the Constitution, our first duty is to establish justice. In a lot of the immigration debate, people say it's about justice and fairness. People say, oh, they broke the law. They've committed a crime. They're here illegally. Except immigration courts are classified as civil, not criminal. They are not criminal courts, and therefore you have no right to an attorney. And so, as a result, as in, I'm going to say most court proceedings, the side with the most legal knowledge tends to win. They have a huge advantage, which is why we talked about the tax on lawyers funding as a way to rebalance the scales of justice and ensure that everyone has access to a basic threshold of legal knowledge that has everyone who's arrested gets at least $600 to spend on hiring a lawyer to ensure that they can get some access to basic knowledge. That being said, to have a fair trial, to have a system of justice, you've got a fair proceeding requires that the participants understand what's going on. You can't have a judicial system making decisions where one party does not understand what's going on. And that is hard to judge in some cases. Individuals, are individuals, there's a wide spectrum of knowledge and intelligence. However, we do, as a practical matter, recognize certain categories of people who, by default, by declaration, are deemed not competent to, are not capable of understanding what's going on, right? You can think of this about laws around consent, an age of consent, and says, well, somebody under this age doesn't have a good enough understanding of the world to legally consent to enter into sexual relations. And however, if you are under that age in a deportation hearing, the court can say, well, you're old enough to understand about this life-altering decision that's going to be made on your behalf. And so this section 536, it's broken down into two parts, two categories. And the first part deals with unaccompanied minors. So according to a September 2020 report by the National Conference of State Legislatures, an estimated between 75 and 90% of children facing deportation did so without representation. These are unaccompanied minors facing deportation, and 75 to 90% of them did so without representation, and the results are stark. 80% of the unrepresented minors got deported, compared to those who had representation, just 12%. Access to basic legal knowledge levels the playing field. When only one side, when the government has all the knowledge and resources information, they're putting their thumb on the scales of justice. And so we, the people, our duty is to establish justice, and we can help rebalance those scales. Let's take a look at what the existing law says about unaccompanied minors. And it says, wrong button. It says that unaccompanied minors, the person concerned shall have the privilege of being represented at no expense to the government by such counsel as he shall choose. At no expense to the government. So the law is very clear. The government does not, we're not spending government money in removal, deportation hearings. All right, with that in mind, that's the reference that's going to come up here as I pull up our next section of the legislative package. Authority for appointing counsel to certain individuals. All right. So the existing law says that the Secretary of Health and Human Services, to the greatest extent practical, consistent with that section of law that says no government spending, to the fullest extent practical, all unaccompanied alien children who have been in custody have counsel to represent them in the legal proceedings. So to the greatest extent practical, shall make any effort to utilize pro bono counsel who agree to prior representation. So this is official policy, is that we will try to find you free legal representation, but we don't want to spend any money on it. So what we're doing in this section is adding an exception, except as provided in subparagraph B. And subparagraph B makes an exception. An unaccompanied alien child who is 13 years of age or younger shall be represented by counsel. Now, sort of like that, the 10 years for updating the registry program. Is 13 the perfect age? Not necessarily, but it's a place to start. It's a middle ground to draw a line and say, look, 3 and 4-year-olds can't represent themselves in court. What is the right age? 13 is a very reasonable place to start. Say, look, you're here by yourself. We're going to make sure you understand what's going on. We're going to make sure that you're being looked out for. We're going to try and establish justice and make sure you're treated fairly. Remember, 80% of unaccompanied minors without representation get ruled against, and compared to 88% with representation, the ruling comes down in their favor. There's a huge difference. And again, looking out for children is just like should be basic human nature. So, exceptions for certain children. Again, do their best to determine their age, and it attaches to administrative reviews and appeals, and no later than January 30th, 3 months, the Secretary shall implement this subparagraph. Yeah, okay. Our next section here is representation. The other half of 536 here is representation for certain incompetent aliens. Again, fair hearing means that both parties understand what's going on. And so if an incompetent person, by definition, is not competent to understand what is going on and represent themselves. And so we have a responsibility to ensure that they have their interests are represented. So what this does is create an authorization to appoint legal counsel if pro bono counsel is not available and the alien is unrepresented, found by an immigration judge to be incompetent, and is engaged in removal, deportation proceedings. The presumption is that they're competent, but the immigration judge, if there are indices of incompetency, the judge can make a decision. The effect of finding someone is incompetent shall not prejudge the outcome of any proceeding. It's just to ensure that they have legal counsel. And once again, ability to prescribe regulations. And so the section of law, updating the references, exceptions for certain populations. The federal government is authorized to provide counsel at its own expenses for unaccompanied children, described in that previous section, and subject to appropriations, certain incompetent individuals. Once again, these are popular common sense provisions. 75% support for ensuring that unaccompanied minors have legal representation. For incompetent individuals, it falls to 67%. But again, these are common sense things, and until Congress is willing to deliver on a major overhaul, these are temporary things that will improve the status quo, right? Remember what Dr. King said in his Beyond Vietnam speech, that our only hope today is to recapture the revolutionary spirit, to go out into a sometimes hostile world, declaring eternal opposition to poverty, racism, and militarism. And with this powerful commitment, we shall boldly challenge the status quo. So these provisions, these immigration provisions, challenge the status quo. Now, you might be thinking so far that all of these things are, say, liberal provisions. They are pro-immigrant, to path to citizenship for kids who were brought here illegally, or those who've been here for more than 10 years, or people who need representation in court, or children's access to get, in-state tuition. So on the other side of the coin is going to be, starting with section 541 here, is mandatory use of a verification system for large employers, an electronic employment verification system. And this is something that is more popular on the right. Let me start from the beginning. So back in 1996, Congress passed the E-Verify system. You may have heard of it, and it was and is an opt-in program that employers could use to verify that someone they wanted to hire was eligible to work in the United States. It was passed as a pilot program, and that's how it's still on the books. There's an expiration date, a sunset, that was, again, it was a pilot program, and they just keep updating the expiration date every once in a while. Was it Reagan who said there's nothing so permanent as a temporary government program? So that was in 1996. So almost 3 decades later, where are we today? And the answer is more than 20 states currently mandate some use of E-Verify, including most southern states, for private employers. Florida requires it for private employers with more than 25 employees. You're required to use E-Verify for employment verification. So what Section 541 of the Trump-Biden peace plan would do was make this a permanent program and make it mandatory for large employers in 3 phases. You'd have 6 months for if you have more than 10,000 employees. If you have more than 1,000 employees, you got 12 months. And for 100 plus employees, you've got 18 months. It would still be accessible as a voluntary program for anyone else who wants to use it. And if you were ever accused of hiring someone that was not authorized to work in the United States, this would establish an affirmative defense. If they came back and approved, if you ran them through the system, they came back to prove, that's your defense. You are in the clear. You're in the clear. So we're going to look at this next section, and there's a lot of text here because this is a sort of a general updating of the entire system, requiring employers to comply with verifying that the people they hire are eligible to work here. So sort of like the DACA provisions, there are types of documents that a person can use are listed. There's also a number of statutory penalties that are increased. Again, Congress hasn't updated these thresholds in many, many years. So you'll see a number of penalties are increased so that there's still penalties and not an amount that is, insignificant. There's also federal contractors. If federal contractors who violate this law, the larger law requiring them to ensure their employees are eligible to work in the United States, federal contractors who violate this can be barred from receiving federal contracts for up to 5 years. Again, if you're going to So A couple other things. I'm just going to give you an overview, and then we're going to kind of skim through the bill. But it's a lot easier to describe, I think, up front. So, enforcement, it moves from the Attorney General to the Department of Homeland Security. They're also responsible for funding this program, Department of Homeland Security. And that's section 540. That's section 542. 543 establishes a fraud prevention program. Parents can block the use of their child's social security number, for example. And we'll just come back before we get to look at the minutia here. Again, advocates for immigration reform, they often oppose these mandatory e-verify systems because they are imperfect. They are imperfect. There is a small number of people who can slip through the cracks and be their citizens who are eligible to work here and can be told, no, you're not. Again, we're a nation of 330 million, we said 250 million adults. And yeah, no system is perfect. But just because there are a non-zero number of cases where something goes wrong, doesn't mean the solution is to do nothing. That is not to let the perfect be the enemy of the good. So again, this whole section on immigration is considered as a compromise. In exchange for the paths to citizenship for the long-term undocumented, we're also going to ensure that large employers are verifying the status of their new hires. And like all these other provisions, let me also say this is popular. A Pulse Opinion Research poll found 79% in support of electronic verification. So many states are already doing this. We're going to make national policy that large employers have to verify. Like all the other numbers, 13 for unaccompanied minors and 10 years for the registered program. Is 100 employees the perfect number for making it mandatory? I don't know, but it's a very reasonable place to start. So let's make the big reasonable changes first, and then we can reevaluate in a couple of years and see what's working, what's not, where the problems still are, and what needs to be updated and addressed. Again, the American Union, this is not a one-off. This is not a perfect solution that's intended to fix everything for all times. The American Union model establishes a new process for applying those principles of self-improvement to ourselves as a nation, creating a path for us to continually update our laws by bypassing the dysfunction of Congress. But it does require individuals willing to do the policy work and work out a reasonable middle ground that can appeal to that key 3.5% chunk of voters who want to see things get done instead of politics as usual. All right, let's blast through this last section of law. Again, there's a lot of pages here because unlike federal legislation that they make changes to the law and say on such and such paragraph 3 the word is changed to shall, or whatever, where it's very hard to read and understand. In the Trump-Biden peace plan, the vast majority of cases, we show the existing legislation so you can see what is being changed, as opposed to just a sentence that says in subparagraph A1A, for a fee is struck through. You can actually see exactly what is being struck through. So, all right. So this is, again, offering, this applies to people hiring, continuing to employ. So we're adding this because this will apply to these large employers who are continuing to employ. It is unlawful for a person after complying with with these requirements to continue to employ. Again, that affirmative defense, updating references from the to the Secretary of Department of Homeland Security instead of Attorney General. Lots of existing law just staying here, but it's all available to read. Definitions get moved to a later part of this section. During the verification period, you can use electronic and telephonic formats for verifying. Doesn't have to be on paper. Got to use a social security number. Here's the some documents that you can use. It's got to be an unexpired. We're adding the word unexpired passport or passport card, permanent resident card, authorizations. Contains a photograph and biometric identification data. Or an unexpired state-issued driver's license to establish identity. What else? You're supposed to keep a copy of this for 3 years after verification or 1 year after employment is terminated, whatever comes first. So keep a copy of that. You get confirmation through the system. If you continue to employ someone after you've gotten final non-confirmation, the presumption is that you are violating the law. Here's the staggered mandate for large employers. Again, 6 months, 1 year, and 18 months. Transition rules. Job offers can be conditional on having employment authorization confirmed. Re-verification for individuals, previously hired individuals. You've got to can re-verify if you're subject to those things. If there's suspicious activity, the Commissioner of Social Security will let employees know that there's a pattern of unusual multiple use with their Social Security number. Again, it can be voluntary. People can comply early. You don't have to wait. And same, you can be the previous e-verification users. There's a possibility for an extension if needed. This subsection D lays out the employment verification system, an opportunity for, if it comes up as a tentative non-confirmation, to appeal how the system shall be designed and maintained, making sure that we're preserving the security of the information by using algorithms to identify potential identity theft, to detect misuse of the system, developing capabilities to detect potential fraud or misuse, auditing, and allow for auditing use to detect fraud, misuse, or identity theft. Having safeguards, responsibilities of various commissioners, then a whole bunch of stuff here from the existing law gets struck that sort of implemented the pilot program. Compliance, just updating some references here. You can see here we're updating the fine amounts from $250 up to $2,500, and so it's kind of updating those. Let me just say this section was compiled from 3 or 4 different proposals, and most of them wanted to 3 or 4 different congressional proposals, and most of them wanted to increase the fines. Exemption from penalty for good faith. Criminal penalty, just updating some references there, penalties there. States can also do enforcement And then we've got definitions here at the end: data verify, e-verify, recruit, refer, Secretary of Homeland Security, all those things. The verification period is 3 business days after the date of hire. Okay, and we talked about 542. This is going to be funded by the Department of Homeland Security, beginning in the 2026 fiscal year. The fraud prevention provisions, allowing parents to prevent theft there. And then, as I said, the original program was supposed to be a temporary program, and so this will repeal it. All right. That's our hour. That's going to conclude this discussion on immigration. Hope you can tell I'm still feeling good with my fast. My weight is down to 177 pounds. And I hope you join me tomorrow evening at 7 p.m. Eastern Standard Time. And we're going to talk about the pollution fees that serve as clawbacks.